So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's the Minister of Finance at the time, I think Kwame Boproso, had prepared a budget which he was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there, and the then majority said that we are going along with it. And James Mensah said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament?
Yes.
Rollins 193.
Yes.
And then 196.
Yeah.
So that was the second, my Lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court heard that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of recurrence violations of the Constitution, the provisions of the Constitution. So depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy courts. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if it demands that they must be pragmatic, they have to do it. So that is my answer to your question. Thank you.
Very well, my Lord. My Lord, you've spent the better part of your adult life after your call to the bar on the bench. I once remember you in your court saying that though you, the judges, don't go out, but perhaps you are the first to hear of every public rumor or gossip. I remember you telling us in your court. What it means is that you are equally aware of criticisms that emanate from the public space when you speak to shape governance and public opinion. Lord, would you agree with the position by some critics that the Supreme Court of our country has had the occasion to miss opportunities to provide judicial leadership in advancing constitutional justice and or protecting fundamental rights?
The Supreme Court has neglected its duty in shaping the... Is that what you said?
Oh, my Lord.
Can you...
Very well.
Please?
Very well. So, you hear of criticisms. Definitely, even amongst you, yourselves, your judgment could go up and your brothers above you will say no. I am saying that the feeling that there are times that our courts have missed the opportunity to provide judicial leadership, which leadership would have helped in advancing constitutional justice or protecting fundamental human rights. Would you agree with me that we've had instances like that?
I disagree.
Okay. My Lord, much as I appreciate your answer, is it your case also that in all situations the Supreme Court has scored 100% in providing 100% judicial leadership?
I will not say that it's 100% because it's a human institution. Because the judges have the right to go right, they also have the right to err. That is why Article 129.3 even provides that when exigency comes or when there are situations that the Supreme Court will have to depart from its previous decision, they have the right to do so. They will not come out to say that they were mistaken anyway. But in doing so, they will require that there are exceptional circumstances for them to depart from their previous decisions. And then two, it must also be said that the exigencies of the time demand that they depart from their previous decisions. So I would say that being human institution, they are prone also to make mistakes. They are human beings. I mean, and there's no judge under the sun whose decision has not one way or the other not be overturned. We are human beings. It's only God who is perfect.
Therefore, we've had instances of missed opportunities in judicial leadership. Now, my Lord, let me bring you back to this case you decided at the High Court. And if you can immediately recall, I'll refresh your memory on that.
Which one is that?
Yeah, I'm yet to say it. I'm yet to. In the matter of Ninoy Odonko versus the Iyoko, I can give you the brief fact of the case, just to recollect, for your recollection. If you remember, we would proceed. But if you...
It's a long time ago.
Sure, that's what I'm saying. I understand. My Lord, in the Ninoy Odonko case, Iyoko had frozen Ninoy's account without notice to him. The man had traveled out of the jurisdiction. At the time, his account was frozen. He came back into Ghana after some 5 years and made an application before you. Yoko at the time had already expended the money which was in their exhibit account. Your ruling was to the effect that the time for him to apply was far gone, so time back, procedurally, you could not apply for the defreezing at the time he was. However, the argument that he was not in the jurisdiction, and in fact, when the matter went on appeal to the Court of Appeal, your position was sustained. A certiorari was also filed, and relying on the Supreme Court's earlier decision in a matter I will remember very shortly, he was again denied because applying for certiorari, per the rules of court, you need to do so in 90 days. So this gentleman lost every opportunity at all levels because of the time factor. He was not in the jurisdiction, his money is gone, and his fundamental human rights had been infringed upon. His right to have access to his own cash in his account had been taken away from him without trial. My Lord, my position is that the approach in interpretation was rather unfortunately very strict in this situation of Ninoy Odonko. And I consider it as a missed opportunity for the judiciary to have exercised its judicial leadership to protect fundamental rights, because on the fact it was all obvious the man has not been tried, he was not even on notice, but he's been affected by time because he could not apply. Equity would not be for his benefit in that instance. What, my Lord, in the present circumstance, would you advise the interpretation approach should be, with this in mind?
In the first place, let me say that I'm very happy that my decision was affirmed. And when you went to the Supreme Court too, you were overthrown. But coming back to your question, you see, judges, I mean, it's right that we do justice according to law. We don't do justice according to emotions. The court that you came to for it was not a what do you call it, human rights court. You were not espousing human rights issues. Okay, you were talking.
But equity will look at substance, not form.
Oh, but the equity follows the law. Equity follows the law. So if the law says that within 1 year, and we started the Financial Crimes Court, I together with this judge who is no more with us. We started, and that time the Eco law had just been passed, so we were involved in it. And I quite remember that there is a provision in, if it has been changed, I do not know because I left the court a long time ago. Under that law, if your account has been frozen and the ECO people do not prosecute you within 1 year, you have the right to come to court to challenge it and have your account defrozen. You see, I'm not sure about whether your client has then traveled out of jurisdiction, and if it did, it wasn't served with notice. I'm not sure about that. But what I'm saying is that once the law provided the time frame within which to come to court, and you were outside the court, look, and it's 1 year. If you stay abroad for 5 years and you come to court, how will equity help you?
Okay, my lord.